Well, good morning. Welcome back to hour number 2 of Tampa Home Talk. I'm your host, Katrina Madewell. Thanks so much for sticking around. And as promised, we've got another very exciting hour 2 lined up with our guest. And I thought, what an appropriate hour to talk about as we roll into this stuff, because I think we're just going to see more and more things happen as these unemployment numbers rise and just, lawsuits that probably would not be as warranted maybe in a different era. I don't know. Maybe that's not the best way to say it, but you get what I'm saying. And so without further ado, I'm going to introduce our guest for the hour, Mr. Paul Ferreria. And he is an asset protection attorney. Help me out with the name of the law firm, will you?
It's the Lexwerx law firm, LLC, in Tampa.
And is that your specialty is in asset protection, or you have a couple other areas of law as well, right?
I do federal government contracting. I also do business formation, and the asset protection is part of it also. So,
and we got a lot of stuff to cover, I'm sure, but when you think about asset protection, and I'm sure everybody in this room and probably even our listeners will have questions, that when do most people seek your service? I guess it's a great place to get started, right?
Well, first of all, thank you for inviting me and having me here today. Actually, most people come to me for something different. It could be they've just created a new business, or they're coming in to do their estate planning, and then I will talk to them about the asset protection portion. So if you're an entrepreneur, if you're an established business person, now that you've got your business chugging along and it's doing well, what about protecting what you have created? What happens if a key person in that company passes, especially a small company? Does your spouse know that business and they're going to inherit it and somehow have to deal or wind up operations for it? Do they understand that business? So these are all things that I actually approach them about and try to question them and see if they've thought about it, and then hopefully, we'll work together on a plan.
That's actually an excellent point, because I always think about, okay, well, if that were me, what's that, my husband would have no idea what to do. And in fact, I would say my people that work for me would know more about not only operations, but where everything is.
Yeah. And that's why you would want to have a succession plan that says this person, while my husband may own it, this person will manage it until we can either, transition it to somebody else or keep it going as is. But you want to make sure that somebody who knows the business is the one that succeeds you.
When I think about asset protection, most of the time I think about, okay, what if somebody gets sued, or it's to protect yourself, right, against getting sued. That's what most people think. And so, one of the things we're passionate about is helping people build wealth through real estate. So when you think about that, right, and people accumulating investment properties, their homestead is protected, but not the additional properties that they own.
Right. Well, that's part of it. Tax mitigation is also part of it. And I want to be clear, it's tax mitigation, not avoidance. You'll always have to pay taxes, but you want to pay the minimum amount required. So it's part of that. Also, you're doing your survivors through asset protection. You can also be doing your survivors, and there's a big favor by leaving everything planned out before something happens to you, before you pass. And it makes the transition a lot smoother than if you pass without a plan. It's a big mess for your descendants and your heirs to clean that up.
And if you got a bunch of real estate and you don't have a will, all those are going through probate.
And probate takes forever.
Not only does it take forever, it's very, very expensive compared to an asset planning. So a lot of times when I speak to my clients, they kind of balk a little bit at the fees for asset planning, but it's not even 1/10 of what probate will cost you, depending on the size of your estate.
We know because we work with attorneys on probate, and it's not fast. It's not easy. There's a lot of things that can come up, and can be a little bit of a slower process than people would like, but this is part of the planning.
That's great.
So when you think about, say, the person, maybe they only own their home, they're listening, they own their primary residence, and they're thinking about putting money somewhere else less volatile than the stock market, like real estate. And, what are your thoughts and your suggestions on that in terms of them purchasing properties for investment?
All right. Well, the number one asset protection mechanism in Florida is the Florida Constitution itself, which contains the homestead exemption. So your primary residence is exempt from creditors, liens or creditors approaching it, except for your mortgage and any liens that were created in connection with the home, like repairs, contractors' liens, or anything like that. So what you want to do with that is make sure that the people who are on the deed, an individual or a couple, that is their primary residence. You want to be careful with adding people onto the deed that is not a primary residence. Like you put your kids on it, they live somewhere else. Well, the portion that belongs to them is subject to creditors' liens, but not your portion, the homestead portion. So that's the number one. That's automatic.
And it can mess up your homestead for taxes and all kinds of stuff.
I have a question on that while we're on that. So what if because it's common for parents to help out their children when it comes to home purchasing. What happens if can you homestead a home if, let's say, the children live in there, that's their main house, but maybe the loan had to go through the parents because they had better credit, more money, that type of stuff? How does that work?
It gets very nuanced, but it would have to be what is the parents' primary residence. You can't have two homesteads. You can only have one. So if they're living somewhere else and they have a mortgage somewhere else and the deed is in their name and they spend a lot, if not most of their time there, even though the second property may also be in their name, it's likely not going to be considered homestead.
Gotcha. What if they don't own any other property, but they live in a different state?
No, it has to be, the homestead the primary residence has to be one in the United States. So the Florida residence has to be your primary residence.
Gotcha.
If you're up in Michigan.
People laugh about this when I say it, but with regards to what Paul was saying earlier, there's a reason why O.J. Simpson fled to Florida.
And there's a reason why a lot of millionaires and a lot of business owners and stuff have built their big mansions down here, because they know if something goes wrong in another state, creditors can't attach. They're protected down here in Florida.
So as someone's building their portfolio with real estate, what do you suggest in general? Should they put it in LLCs? Should they put it in a trust?
I would probably, every situation is sensitive, is case sensitive.
Right.
It's not one size fit all, but I would lean towards advising a trust, because with a trust you can rename the property will stay in the trust. It doesn't have to transfer, and you can change the trustees and the beneficiaries in the trust. It's also revocable, so if you change your mind, you can just revoke it and pull it back and start from scratch. LLCs are subject to. You can put your property in an LLC. You can do similar things and change the ownership of the property by changing the operating agreement in the LLC. But again, it's each individual case, it's nuanced. With trusts, I have not had a problem with banks issuing mortgages on the trust.
Good point.
So yes, I have had some clients come in, they have a ladybird deed on the property, they have some sort of LLC or something, and for whatever reason, the bank won't touch it, so we have to undo it and put it in a trust, and the bank will issue a mortgage or
it's the way it guarantees and the way it resells in the secondary market. They don't like it, so it has to be very specific. Yeah. Leo, you do a lot of this too, right? Like you don't personally own you put your stuff in other entities. Do you do LLCs or
I don't know
trust?
What you're talking about.
Okay.
I own nothing. And nothing can be traced back to me except for a PlayStation and a laptop.
We see where I've seen where some people have trust, and it's actually, you'll know the better terminology than I will, but I've seen where it's buried, like the person is buried so much through different layers that it's hard to find it.
Trust own LLCs.
Yeah, step down trusts. There's a lot of verbiage.
Shell corporations, we like to call them.
What would be the reason? What would be the reason to do that?
To
bury it like that, why would you?
It's hard to trace back the owner for lawsuits or whatever.
And to find it,
Yeah, we have to be careful, because if you were intentionally avoiding creditors or something, the transaction could be, a court could nullify the transactions and approach it.
I'm not talking about avoiding them. I'm talking about somebody that just set it up like that from go.
You can set various layers. It'll make it more difficult for creditors to proceed if you've done this all before the event. So, let's say the unforeseen, the contingency forbid is a lawsuit, and this was all done before the lawsuit, you stand a much better chance of those trusts being upheld by a court and defending, as as opposed to, oh my gosh, I had an accident last week, went into my attorney's office the following week, and now I'm doing all of this. It could be interpreted as trying to avoid the creditors.
So when we come back after the next break, we're going to talk about where and how to get started, and then there's a bunch of questions that Paul gets on a regular basis, and we're going to answer those on the air coming back in just a few
I
minutes.
feel like I want to know if my gun trust can own a condominium.
Off-air number 813-377-2775. There goes Leo. 813-377-2775.
It's a legitimate question.
We'll be back in a minute.
Well, good morning. Welcome back. This is Leo Kane with Barrel Engineering and Inspection, asking the tough trust questions right now. Very tough.
Well, I find the very first question at the top of our list super comical.
Oh, then let Adam read it. He's our comedian.
Yes, I will.
What's our question? Very top of the list here.
Starts with can't.
Oh, can't I just Google an asset protection plan? Yeah, I'm a millennial. I can Google this.
could.
I can figure this out, right?
You most
Okay, Google, give me an asset protection plan.
You could.
Okay.
Oh, awesome.
You most absolutely can Google it. I don't recommend it because I don't know which website you're going
A
to.
piggy bank popped up. Photo of a piggy bank. That's
I
good,
don't know
right?
what.
You have to think about the source of it and information, and blogs. Anybody can write them with any opinion ever, and it doesn't mean it's factual
But
information.
Wikipedia is legit, though. So
It's not. It may or may not be conformed to Florida law, and then there's
Oh, yeah, that's
little,
the big one. It may not be conformed to local law.
and there's those tidbits of advice and experience that only an attorney who's practiced in that area can give you. Like, I just mentioned before, banks will mortgage trusts. They won't other types of plans. So if you can create something, and you're assuming a lot of risk when you're doing that. And with an attorney, at least you're minimizing that risk.
what about the, how do you feel about those online legal services? Not to mention anybody by name, but obviously blankandblank.com.
Hey, it could be garbage in, garbage out.
Yeah, I mean, it again.
Get what you
I'm
pay
not,
for?
the law is evolving.
That's like saying. Yeah, I can just sell my house on Zillow. You could. Be an option.
It's possible. It's possible. It's a lot of work.
Does that mean you're going to get the highest and best price? How much is it going to cost you if you do something that you are not supposed to be doing, and now you have to hire an attorney to pull yourself out of your pickle, if you will?
Well,
So-
I do know this. Back when Florida Statute LLC law changed, I guess Florida Statute 605, 608, when that went into effect, the .coms and Zooms out there had no idea what they were doing.
And that's my point. The law's always changing. There are little nuances, and it could take 6 months to a year for that website to catch up on laws or changes that happened last week or last month.
Can we take a question from one of our listeners, Paul?
Absolutely.
I think we have Eva on the phone, right? You have a question for us?
Yes, I do. Hi. I have a question regarding a existing mortgage. Is it possible to put a POD on a mortgage or a house or a property that you currently have? And if you can, does it have to be no mortgage on it at all, free and clear, or how does that work? Or is that something that's possible?
Are you saying you want to put a POD on the deed so that it goes to somebody else should something happen to you?
Yes.
Okay. Usually when the property is mortgaged, you need the mortgage company's permission to change the deed.
Okay.
Right. I have had mortgage companies not complain when, for some reason, the property is in the name of one spouse and they want to add the second spouse. I haven't had any issues with that, but yes, you must get usually you must get the permission of the mortgage company to change the deed on their collateral.
There's a little clause in your mortgage that you sign called a due on sale clause. And so what that means is if you did that and you changed the deed, your mortgage company actually has the right to call the entire note due.
And I just want to clarify, I have not seen a deed in Florida that has paid on death on it. The POD usually goes with bank accounts. You can go to your bank and you can tell them to, should something happen to me, I want the funds to go to this person, and they'll do that. I have not seen a POD on a deed. There are many different types of deeds, but usually you will need to add a person. You will actually need to add that person on the deed with rights of survivorship to have that property go to them. But then again, if that person's not living there, you're putting your homestead exemption at risk. If they don't, because now their portion of that property is subject to their creditors if that's not their primary home. And yeah, usually you would need a will would pass that, or to somebody else through the will, not necessarily through the by putting POD on the deed.
When you think about that in general, like the POD compared to a will, compared to a trust, what's your thought on those comparatively speaking?
Well, they're different they're different documents or mechanisms for different reasons. So a trust is a separate legal entity, like a corporation, like an LLC, and you are putting certain assets there, and there are certain legal requirements. It has to have trustee and beneficiaries, and you're using it for legitimate. You can create almost a trust for almost anything as long as the purpose is legal, all right? And then as long as it meets those criteria, you can create that trust. And it's just a separate legal entity so the assets that are in there don't belong to you. They belong to that trust. With a will is directions on what you want to do with your estate. Where do you want it to go when you pass? All right, and
keeping you out of probate.
Right, and keeping you out of probate as much as possible. And then your POD is really a designation. It's not a contract. It's a designation that you put on your bank accounts and your investment accounts that say, should something happen to me. So your bank accounts usually pass outside if they're properly written up, if the account is properly designated POD, it will pass outside of your state and it'll go directly to the person that is on that account.
And this is really where talking to an attorney can make the difference, in my opinion, because if somebody wants a POD, there's usually a reason why, right? So if it's somebody else, it's a child or somebody else, right? And then what happens if there's a spouse involved? That can really muddy the waters after someone passes, right?
Yeah. Well, when I talk to my clients, I usually go through the life cycle. There's usually, the first document I recommend is a power of attorney, which is you're giving authorization for somebody else to act on your behalf, to be your legal representative while you're still alive, and for some reason you can't. You're unavailable, you're out of the country, you're sick, or you can't make your own decision. That's document number one. The second is a living will, which gives, same thing, it designates somebody to be your representative to make medical decisions on your behalf in the event you can't, and you take away the final decision. So in that there's a medical directive there where you're telling your doctor, should I reach a certain point and I cannot continue to live except through artificial means, you're asking them to discontinue. So that's why you're sick in your last days. And then there's the will. That's after you've passed. You have now explained, this is how I want my things to be distributed.
Right. Eva, did we answer your question, or do you have additional ones?
Partly, the other issue I have is if the house is paid off and there is no existing mortgage, then how would a POD be processed?
If there's no mortgage on the property, you can add somebody to the deed, or you can make sure that the deed has rights of survivorship on it. So that means if there's multiple owners, two owners, let's make it easy, A and B, and if the deed is written up properly and has a right to survivorship, when A passes, B gets it.
Right.
Without having to go through a will or anything, or through probate.
And does that make it bypass the probate?
Yes, it should. If written up properly, it should.
Okay, so basically we're looking at the rights of survivorship has to be in place.
Right.
Correctly.
The caveat there is be careful. If you're adding somebody, though, that doesn't live in that property, it's not their principal address, you're putting their share is subject to their creditors coming after
right.
that home.
This is where I think, like in this situation, and obviously you wouldn't know without really talking to her in depth, but it sounds like maybe a will or a trust or something would make more sense.
Could, yeah. If the property is paid off, there may be other solutions that will get you where you want to go better and protect you better.
Versus impacting a homestead exemption or putting your property at risk to creditors with that other person.
Yes.
So there's a lot of layers. What was that?
Got it. I was just commenting on what you were saying. I never thought of the other issues
People never do, and that's where attorneys really hold their value, and that's why we have these shows, because people hear something, right, from one person, and they say, oh, well, so-and-so did this, this works. Well, you don't know anything about their story or their situation or their other assets or their debt or if they have creditors. So you have to, it doesn't, just because one looks like an apple doesn't mean the other one's an apple. You could be comparing like an apple to a banana. So that's where like really having the breakdown with the attorney on everything, letting them understand the whole picture, then they'll give you some good, solid, sound advice around your specific situation. Make sense? And
Yes, thank you.
Eva, I can get you connected with Paul off the air. Thanks for your call and thanks for your question. We appreciate it.
Thank you. Bye-bye.
And so we're going to talk a little bit about what are some solutions to shield assets and protect what you already have, and to think about like what this looks like growing and going forward as you build assets. Everything from cash to anything that could be liquidated, right?
Yes.
And then maybe you could share some stories even about some things you've had in the past where you've helped somebody with asset protection and it worked out really well. Here's what happened. And times when they were trying to get it and it was too late. So this is Tampa Home Talk. Our off-air number 813-377-2775. Again, you can call or text. Questions you have, we'll answer them on the air or get you connected with Paul. 813-377-2775. Last time, 813-377-2775. We'll be back. Stick around. Real quick break.
10 seconds.
To Tampa Home Talk. This is Adam Talley with Talley Insurance. And before we dive back into asset protection, let's talk about saving you a little bit of money on your homeowner's insurance. Our tip of the week, and I still get
talk about asset protection. Your insurance is that.
It is. It is. Well, and I get surprised, and I saw it this week. I saw it last week, where people get their roofs replaced, but they never tell their insurance agent. So we get up to a renewal. They're like, man, my rate went up a little bit, but I got my roof replaced last year. Do you think that would help? Well, yeah, that would help a lot. We should have done this 6 months ago when it got replaced.
You know what? I'm guilty too, because I put in 2 solar attic fans and lights and had all kinds of tax credits and forgot to file it.
So if you replace your roof, that's one of the best times to shop around your homeowner's insurance. The age of your roof and its construction features are the number one rating factor in the state of Florida when it comes to your price on homeowners insurance.
What percentage roughly do you think the premium goes down when you get a new roof?
It depends on the home and the size. Everything's dependent on
Right.
the size, but percentage on an older home, I've seen it go down 50%.
Wow.
Yeah. So huge.
I would not
it
guess
pays
that
for
much.
it pays for itself for sure.
That's why you got to get them wind mitts.
Yes, you need to call Leo, go to Beryl, have them give you a wind mitigation. And again, it's on the actual construction features, not the condition. So even if you haven't had one in a while, get a wind mit. It's worth it.
So I would love to talk a little bit about just like kind of bringing this back to real estate, Paul, because I think the biggest thing that we see, like a lot of the questions that we get from our people is as they start accumulating investment properties, what can they do to protect themselves from like the tenant suing them, right? Or the tenant having somebody over and they fall and break a leg and now they want to sue the homeowner.
Well, you bring up a good point. The first line of defense is insurance coverage. So you want to review your insurance coverages for the property, kind of assess the risk, talk to your broker, and determine, do I have enough? There's also extra layers of insurance you can get, an umbrella insurance policy, so that if something happens and the limits of the first insurance policy are reached, you can go to the second umbrella. And that's your first line of defense, because they would only come, if the loss is covered, they would only come after your personal assets after you've expended all of your insurance.
Can I also add, if you do own a rental property, make sure that your tenants have renter's insurance, because that's going to provide them liability, and that will, again, be another layer for you, especially if it's the tenant's guest that's on there, I would say.
So as far as preventing people from suing, unfortunately, I mean, as long as they can go down to county courthouse and file a complaint and pay the filing fee,
Right.
they can sue you. Winning is a different matter. And if you're in business today in the United States, you're at risk and you will likely be sued for something, whether it's good, right, or indifferent. You risk being sued. So your first line of defense is insurance.
Okay.
And then with your real estate, if you're in the if you're doing this as investment, if you're doing real estate as property, you may want to create a separate legal entity. It may be an LLC, it may be a trust, it may be something else for each individual property. So when you start to commingle all your properties together and put several properties in one, then they're all at risk for one claim. If you have them in separate one, they're separate legal entities. So the person would have to have a claim against each legal entity to.
Are you doing a
them.
Florida land trust, or is it a different type of trust? Because they vary, right?
Yeah, it depends. It depends on the needs of the client at the time. You can do a land trust. You can. So, like I said, you can create a trust as long as the purpose is legal, and you can put almost anything inside a trust.
What are some of the differences when you look at a Florida land trust and just a regular trust? How do they vary?
Well, a regular trust may have. A land trust obviously is for land, it's for property, and a regular trust or a more generic trust may have property in it and may have investment accounts in it. It also may have what's called a step-down trust. So let's say there are 5 beneficiaries of that trust, and 4 of them are, we all have somebody in our family, 4 of them are responsible adults, but there's that one black sheep that, the creator of the trust knows.
Yep.
If they get this money, they're going to spend it within a week or two. So they may, within the trust, they may create a mechanism where that trustee of the trust will say, every year you're going to go get X. If you need more, you have to come ask me for permission.
Can you put more stipulations on that?
Yeah, you can make it very restrictive. There's a broad ban on that, but we've all got somebody in our family like that.
Yes,
so,
we do.
So
everybody does.
A land trust would be just for
I have a member of my family that literally blew through almost $1 million in less than 2 years. Nothing to show for it.
Yeah.
Didn't even pay off the house.
Yeah. That's most lottery winners are broke within 3 to 5 years.
And it's, but it's really how people think about money. And if you don't have any, you don't save any, which means you think about money totally different than someone that is a millionaire. That basic premise of saving 15% of your income for investments. Right?
Yeah.
It's so simple, but it's how people think about it. And it's not like if people like that get a windfall of money, they're thinking, how can I invest it so that it makes more money and it will last longer? When people that don't have any money get it, they think, oh, wow, how fast can I spend this? It's the consumption mentality. Mm-hmm. And then it goes faster than people think.
Yeah. I've been practicing for 30 years now, following the money for 30 years. And people who have money, real money, hide it. And play it low key. People who have just gotten into the money show it off. So you can see that difference. And the Warren Buffetts of the world, if you look how they live, it's way below their means.
Well, you know what the average millionaire drives?
Mm-hmm.
An F-150.
I read that book. That book changed my life. The Millionaire Next Door. I highly recommend it.
It's the truth, though.
Didn't we interview the everyday millionaire people on the people that wrote the book on the show? And there's like 11 million millionaires and.
I don't remember. I've been doing radio for a long time.
There's a lot of millionaires. I mean, it's really easy now to become a millionaire.
Yeah.
Comparatively to when we were growing up, back when the dinosaurs roamed the earth.
Okay, let's not get crazy. So when you think about you talked a little bit about tax strategies earlier in the hour. Are there any specific tax strategies to maximize how much of the assets people can keep?
Well, yeah, there's the basic stuff is contribute to, and very basic stuff, max out on your IRA and 401k contributions. I know it's a tough haul for a lot of people, but if you can do it, put your money there. There's a lot of mechanisms that people just ignore or bypass that are your first step. Before you start getting fancy with your tax mitigation strategies, are you doing the basics?
I like Roths, but I like real estate better.
Yeah, so and then there's and diversify your investments. You can have some in land, some in the stock market through your 401k.
You know what drives me crazy about a Roth? You can put all this money in there. You can be doing amazing. And then something like COVID happens and there's your balance. With real estate, you just don't feel it. You can see it, touch it, rent it. Your rent's not going to change, Now, granted, there's a moratorium that was just extended till June. But for the most part, that's not going to be in place most of the time.
It depends on how old you are, and you have time. If you're young enough to recover, so I've been through the 07, 08 recession, and now COVID, and my portfolios, because I didn't panic and sell, they slowly got their market back. If you're in an end stage of your life and you need that money now, it's going to hurt because you don't have enough time to recover.
Right.
But don't panic, and just America's not going to go away.
Right.
Everybody wants to work, and as soon as they get the opportunity, they're going to start working again and rebuild. So just stay. If you don't need that money now, don't panic and don't sell your portfolio.
I would love to talk a little bit about like asset protection as it relates to legacy and leaving your legacy for your family, because I think that's a big picture.
Well, you're doing your family a huge favor by setting out what you want before you pass. I don't do this, but I highly recommend a pre-planned funeral plan and prepaid for your family, so it makes the decisions for them easier. They're mourning your loss, and now they have to pick out, your final resting place. That's part of it. You can, in your will, you can be very specific. If you have a classic car that you want to go to a certain nephew or something, you can do that. You can also leave, and it doesn't have to be a person. You can leave money to a favorite foundation, a favorite charity. You like the opera, you can give it to the opera. You can give money to. I have a client who just gave a couple $1 million of his portfolio to a church that he's been attending and very active in. So that was his desire. So that was part of his legacy. And that church can go off and do good things with that money now.
One of the biggest things I would imagine people might see is planning, but then your assets and your wealth grows and you don't update your trust or will.
So my first consultations are free if and I will spend whatever it takes with the client. I don't say it's 1 hour free. If it's 30 minutes, if that's all the time it takes, that'll be it. If it's an hour and a half, I'll sit there with the client. But I have clients who bring in their old wills, 10 years old, 20 years old, and sometimes I tell them, based on your change in circumstances, you need to update it. But I've also told them this is fine as is. Usually a significant life change status will trigger some reason to update your will. You got married, you got divorced, you had kids, you bought property, or
minor children are now adults, right?
Minor children
That's
are now
where we're at.
Now adults. Your will was done when they were kids, so you assigned a guardian to them, and who was going to manage the estate, and the money was going to go in trust. Well, they don't need that anymore because now they're adults, so you can rewrite the will to update.
Or now you know what type of adults they're going to be, and you might need to put the stipulations in there that you had before.
You may even want to disown them.
So I love that you offer a free consultation, and I'm going to give out our off-air number if you want to connect with Paul and his law firm off the air. He's going to give you a free initial consultation, and our number is 813-377-2775. Just text Paul, and we'll know you're looking for him. 813-377-2775. So what about elderly parents and that sort of stuff, especially if people haven't done any estate planning, or it's like the white elephant in the room. Nobody wants to talk about it, right?
Yeah, I have people in my family, siblings, who don't want to talk about the demise of my one surviving spouse, but that is very common. You keep kicking it off because it's an unpleasant thought. But yes, senior citizens can definitely benefit. I would partner with somebody who's got more experience in the senior area law, but the biggest risk that they face is their last medical bills from their last or final stage illness. Those can go, those can deplete a elderly person's savings that they intended to, go to their children or their grandchildren or great-grandchildren. And now you find that, after insurance, there's assisted living is very expensive,
That's where long-term care insurance comes into place?
But very expensive to get it. Again, that's another review of your insurance. You're young, long-term care insurance is not that expensive. As you get older, the price starts going up because it's more likely the insurance company's going to have to pay out on it.
Right.
So if they don't have that, there are steps you can take, but you have to be very careful because...
Stick around. Hold on, we'll be back in a second.
Okay.
Welcome back to Tampa Home Talk. This is Adam Talley with Talley Insurance, joined by Katrina Madewell with Keller Williams. And obviously the smart one, Leo Kane with Barrel Project Engineering and Inspections. And we have Paul Ferreira on, and he is a...
Just because it can beat us all at trivia, right?
Yeah, and what was the name of your law firm again, Paul?
So it's the Lexwerx law firm.
Lexwerx.
1550 West Cleveland Street, Suite 8, Tampa, Florida, 33606. And I can also meet with people in Riverview and up here in Lutz if that's more convenient for them.
And by Zoom, I'm assuming?
By Zoom, actually, we're Zoom and other Skype, whatever. We'll find a way.
You want to make it happen, he'll make it happen.
So I would love to just chat for a minute on like 3 documents everybody should have or conversations they should have with an attorney about estate planning if you have any assets at all.
I think I mentioned the 3 documents before. I would start off the very basic: power of attorney, a living will, and a will. And then we build from there.
The difference between the will and the living will?
Living will gives somebody else legal authority to make medical decisions on your behalf.
If you're still alive, right?
If you're still alive, but you can't because of your medical condition. You're in a coma, you're unconscious, or you're not mentally capable of making your own decisions. And then
how is that different from medical directive, or are they the same?
Well, the medical directive, I was about to say, it's part of the living will.
Okay.
But the medical directive kind of takes away that final decision from your personal representative, and it tells your doctors that if I reach one of these 3 stages, terminal, not likely to recover, can only be alive based on artificial means, I am directing you, my doctors, to disconnect me from those artificial means and let me die naturally.
I guess my husband and I are really simple when it comes to this. Like, we pretty much know, like, when we would not be connected or not. We're not doing a funeral. There's a celebration of life, and we're cremated. It's really simple.
I'm seeing more and more in that.
We've done it for years, and we were the weird one, and now people are thinking we're not so weird.
I see that more often than not. The people are now asking for cremation and a celebration of life.
We got to think 15, 20 years ago when we said that, people were thinking we meant funeral, and it's like, no, we don't really do that. Like, in my family. And, there's still members of, like, my in-laws' family that I don't even talk to because we don't do funerals. So we don't really go to funerals. We don't do any of that. And it's not anything, it's just how we are. But, yeah, it's becoming increasingly popular. If you will. Yeah. So, but it makes things simple. And would you address that still? You probably should, right? In your will?
No. Yes, you can address that in your will, and I recommend you. There is a section that I ask everybody what they would like to do. Some people want a very traditional burial in the religion that they were raised in. You can put that in, or they want something more modern, which is a celebration of life and cremation. And then some people want their ashes kept in an urn. Some people want them spread out over a place that's special to them, whether it's the ocean, a certain beach, or whatever. You can leave that in your will and leave those directives in your will.
So for someone that wants to meet with you and have a free consultation, we highly recommend you do it. Our off-air number is 813-377-2775, 813-377-2775. I need to update my own, so I'm going to take you up on that consultation. Okay. As we're talking, I'm like, yeah, mine was little. I don't even really know where it is. When you get it prepared, what about that? Where's the best place to leave that? Are we recording it as a public record document?
So you leave it in a safe place. If you have a safe at home that's fireproof or fire resistant, I recommend that. If you leave it in a safety deposit box, please have somebody else have authority other than you to get to that safety deposit box, because I've got clients who go through the whole estate planning process and then they put it in the safety deposit box.
And nobody can get to it. And the bank says you have to go to probate to open up the safety deposit box. Kind of defeats the whole purpose.
And you don't know what's in there. It's kind of like Al Capone's vault. You don't know what's going to be in there when you open it up. It could be a lot. It could be nothing. You keep it in a safe place. You distribute. I keep digital copies of it, and you can make several copies and distribute it.
That's what I was going to say. Can you have several? Yeah.
To your family. But when the time comes, the court and everybody will be looking for the originals. So
and those are not usually recorded on public record documents, right?
No, there's no place to record them. You keep them. Your personal representative needs to know where they're at so they can access the originals.
Can you have more than one original?
I don't recommend that because that makes a lot of confusion. One original, and then which one, and God forbid if the 2 originals aren't identical, signed on the same date, you're going to have issues.
And do you always have to produce the original? Always?
You don't, but they will first look for the original, and then you have to explain why you can't produce the original, and it becomes a little bit, it's another burden. You have to prove that this is an actual accurate copy of the original, and the original was lost in a flood, a fire, or something. You have to show that before the court will accept it.
Wow.
So it
It
makes
can't
it
just be lost.
No, it could be lost, but you're going to have a burden of, we can't locate the original. You're going to have to reach other burdens to prove that those are accurate copies of the original.
So we're talking a little bit off air, and you actually have an intake sheet that someone can fill out, and
Right.
it tells everything that you need to know and everything to bring in, right?
It starts the conversation. I wouldn't say it tells everything, but it gives me the basics, and then
Makes it an easier place to figure out for you where to
Right.
start.
It makes people tell me what they own, what they don't own, where their assets are, and what they owe also.
What kind of
That's a big
questions
one.
are in there?
Well, who do you want? Who are your children, your beneficiaries? Is your mom and dad alive, or have they passed? Because they could be part of the beneficiary chain if you don't have children. Who do you want to be your personal representative? I usually recommend at least 2, a contingency. So you do your will now, you name Joe as your personal representative. 10 years from now, you pass, Joe's no longer around. What's going to happen?
What
so you
happens
can
if they
have a
don't
contingent-
agree, or is one a secondary?
No, I'm not. No, it's one is secondary. It's
Oh,
a
got it.
contingency.
Got it.
I do not recommend
Having to?
because then there's no tiebreaker. So have contingencies, have one and then the other, but not both at the same time. It's
We know
my
what happens when there's no tiebreaker. The judge
Yeah.
gets to break the tie.
Yeah, and it goes back to probate or something similar. So don't recommend
We should do another whole show on just how to keep your butt out of probate, right?
Yeah.
Because there's a lot of layers there. That one little nuance can change everything.
Right.
All right. So, so those are the 3 documents that I would recommend, and the intake sheet will give me most of the information I need, and then I'll ask questions based. Okay, so you have clients who are big into timeshares. They've got 13 deeds, timeshare deeds.
Do you talk about future intent?
It's about 13 too many.
Future intent
Yeah,
to buy
I agree.
properties or anything like that, or no?
Yes, we talk about future intent, but like I said, if you're creating trust for your existing properties, you might want to create another trust for the other properties that you
We're-
buy or LLCs.
Almost out of time. I was going to ask you for a story. Give me one quick little 30-second story on something that backfired.
Something that backfired. Well, what a big thing that I'm finding now that backfired.
All right, we're going to have to save it for Facebook. So now you guys are going to have to watch us
out of time?
off air on Facebook. We'll also post it on Tampa Home Talk. Off air number 813-377-2775. Get connected with Paul. Get your will and all your stuff updated. 813-377-2775. Remember, love where you live, or we're going to fix it.
All right, guys.
Love.